there's a very different definition under the provincial legislation from what's in the federal legislation, and that's probably one of the single most important differences between the Ontario legislation and the federal legislation, and that's with respect to what constitutes lobbying. In the Ontario legislation, as soon as the communication attempts to influence, then it's considered lobbying. The federal legislation, it's any communication. And so, you know, that as soon as you've, you know, written a letter, sent an email, made a phone call, shook a hand, and it relates to something like a legislative proposal, changes to regulation, perhaps a particular granting arrangement, it probably constitutes lobbying. This is where organizations should be quite careful and really familiarize themselves with the definition. Both government websites, both at the Ontario level and the federal level, have really, really helpful information in terms of how you determine whether a particular activity, whether a particular communication might be considered to be lobbying. And that's where I really encourage organizations to go off and read and test the definition with their day-to-day activities.